Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 7 and 8 on the speed of 90 words per minute. Start. Section 71 of the Evidence Act is in the nature of a safeguard to the mandatory provisions of Section 68 of the Evidence Act to meet a situation where it is not possible to prove the execution of the will by calling attesting witnesses. This section provides that if an attesting witness denies or does not recollect the execution of the will, its execution may be proved by other evidence. Aid of Section 71 can be taken only when the attesting witnesses who have been called deny or fail to recollect the execution of the document to prove it by other evidence. Section 71 has no application to a case where one attesting witness, who alone had been summoned, has failed to prove the execution of the will, and other attesting witnesses, though are available to prove the execution of the same for the reasons best known, have not been summoned before the court. It is clear from the language of Section 71 that if an attesting witness denies or does not recollect execution of the document, its execution may be proved by other evidence. However, in a case where an attesting witness fails to prove the due execution of will as required under clause C of section 63 of the Succession Act, it cannot be said that the will is proved as per section 68 of the Evidence Act. It cannot be said that if one attesting witness denies or does not recollect the execution of the document, the execution of will can be proved by other evidence dispensing with the evidence of other attesting witnesses. Yet another reason as to why other available attesting witnesses should be called when the one attesting witness fails to prove due execution of the will is to avert the claim of drawing adverse inference under section 114 illustration G of Evidence Act. Placing the best possible evidence before the court of consideration is one of the cardinal principles of Indian Evidence Act. Section 71 is permissive and an enabling section permitting a party to lead other evidence in certain circumstances, but Section 68 is not merely an enabling section. It lays down the necessary requirements which the court has to observe before holding that a document is proved. Section 71 is meant to lend assistance and come to the rescue of a party who has done his best but driven to a state of helplessness and impossibility cannot be let down without any other means of proving due execution by other evidence as well. At the same time, Section 71 cannot be read so as to absolve a party of his obligation under Section 68. Read with Section 63 of the Act and liberally allow him at his will or choice to make available or not a necessary witness otherwise available and amenable to the jurisdiction of the court concerned and confer a premium upon his omission or lapse to enable him to give a go by to the mandate of law relating to proof of execution of a will. A reading of the above non speaking order would only show the total non application of mind by the court to the gravity of the crime, the apprehension of tampering with the evidence, and threats to the life of the complainant and other witnesses given by the accused. The High Court passed the impugned order in a mechanical fashion without proper application of mind and without going into the merits and evidence on record against the accused persons. The High Court failed to see and appreciate that the respondents herein, who are the main accused numbers 1, 2, 3, are the masterminds behind the crime committed. The High Court has not considered the material evidence available on record against the accused which prima facie establish the criminal liability of the respondents. The High Court also failed to see that the learned sessions judge, after taking into consideration the seriousness and the gravity of the crime, convicted the accused for the crime. This apart, three other vital factors have also been not taken note of by the High Court. They are the evidence of PWs 1, 2, 4 and 5, who are the eyewitnesses and whose testimony was amply corroborated with each other. Secondly, the identity of the accused persons during the cross-examination was also established. Thirdly, the direct evidence of the eyewitnesses was corroborated by the medical evidence, and the motive of the crime was also established. The trial court has held that there is satisfactory evidence that Rajiv Singh instigated to commit the murder, and at that point of time and in pursuance of that common intention of the accused, they fired at the accused persons. The High Court also has not taken into account the several complaints and information reports before the trial and to the police authorities stating that the accused have killed his two sons out of 6. The 3 accused were arrested and remanded to jail, and other accused are absconding and evading their arrest, and that one of the accused, Rajiv Singh, who is on bail, has confirmed the group of criminals and comes to the house of the appellant and gives threatening to the eyewitnesses of the said order in order to pressurize them not to pursue the criminal case against them. Learned counsel for the respondent submitted that respondent number 1 had already undergone 12 months of sentence and respondent number 2 in special leave petition number 3316 of 2004 had already undergone 22 months of sentence and that the respondents have a meritorious case in criminal appeal, and accordingly the High Court, while admitting the appeal, have released the respondents on bail subject to certain conditions. It is further submitted that subsequent to the grant of bail order, there is no instance on record that the respondents have misused their release on bail, and therefore there is no question of the respondents either trying to interfere with the course of justice or the attempt to tamper with the evidence.